Well, we are going to get started today. Thank you, everybody, for joining us for our next lunch presentation, part of a series, or some people might be just listening to this topic. But we're always looking to keep you updated and informed. So today's session is Planning with Purpose, Essential Estate Planning Tools and Strategies. This is the second in a four-part series. If you want to go back and listen to any other ones, the first one that was recorded, just go to our YouTube page. I'm going to get us started today and keep things moving along. Today's presentation, we will explore why planning truly matters and the difference between succession planning and estate planning. We will review the critical documents that should be in place, managing family dynamics, that's always fun, and planning for retirement cash flow and gifting strategies. So I will start with the housekeeping part of it. You should have a toolbar to the right-hand side of your screen. You can go to the handout section. There is the presentation and also the bios of our experts today. There is another section in the toolbar for questions. Feel free to put any questions in there throughout the presentation. We will try to get them answered through the presentation, and we will save time at the end. We'll go ahead and put those in there. After the webinar today, as soon as we log off, you will get an exit survey pop into your email. If you could just complete that for us, let us know how the webinar was. If you have any questions, want to meet with one of our experts one-on-one, and other topics you would like to hear as I'm planning for 2026. And then this afternoon, I will send you an email with a copy of the presentation again, but also the link to the recorded session if you want to go back to listen to anything or share it with somebody else. So let's get started. So Adam Ohar and Richard are going to be with us today. They are both experts in this topic. The difference is Adam has more of the accounting, CPA, ABB background, where Richard has the legal background to it. So it's a perfect mix for you to get your questions answered and really have that full picture of planning. So that's why they're going to be with us. And before we get started today, and before I completely turn it over, I am going to ask one poll question to you all. Let me get that teed up. And the question is, where are you in the planning process? And this will just help our experts get to know you a little bit more. So guys, where do you think our audience is going to be based on who you saw was joining us? And
let's say have not even started yet. It's going to be later. Just starting, thinking about it.
Good. Then you have a lot of educating too, right?
If it's completed, I don't think they would be attending.
Probably not, unless they're making adjustments.
That's true.
So I'm going to just give everybody another couple seconds to fill it out. From what I can see, it looks like we have an interesting group today. So I'm going to close this out in 3, 2, 1. All right, let's see where everybody's at. I'll just share it real quick. We have a nice mix here. Some people making updates. Some have started, some just started, some not. So that is your group. That's who you're talking to today. So I'm going to hide this and turn it over to Adam to get you started.
Thanks, Carolyn. Hey, everybody. I'm Adam Ohar, a tax principal here at the firm. We're going to jump right in here and discuss succession planning versus estate planning. I know a lot of people use these terms interchangeably, but they do have different contexts and roles. Succession planning is more focused on the future of the business. Really, as a business owner, the primary goal is making sure there's a smooth transition of company leadership to the next generation. You know, as a business owner, you've built up a lot of goodwill, you know, over your life's work, and you want to, you know, pass that along and make sure it's successful to whomever you think is going to run the business, whether it's a child, an off-the-street buyer, you have a pool of qualified employees that you want to turn it over to. But all that goodwill, you want it to pass and, you know, have those employees, customers and vendors, you know, have a continue good working relationship in the next generation. On the flip side, estate planning ensures your wealth, business interests, and family objectives are coordinated. So once the succession is mapped out, yes, that business interest that you own does become part of your broader estate, which requires other planning objectives such as liquidity, possible estate tax mitigation, asset protection. But this will deal with really more your personal assets and making sure that your family's provided for and your loved ones are provided for. There's obviously, a lot of connectivity with both, so it's certainly important that both plans are fully coordinated and just to ensure that the business is successfully run and that it's successfully owned, across generations, if that's some of your desires. Sorry, just getting used to the new clicker here. So, some of the challenges business owners are facing today, whether you're, close to thinking about, an exit from your business or, you're really years away. Illiquidity is probably one of the main reasons, for any business owner, most of their earnings and their assets have been generated from their business. And for most business owners, they usually put that right back into business. So their life's hard work is really in the value of the business that is now be substantially and significantly valuable. Often it's a, more or less wealth on paper. There's the cash doesn't really match the value of the business. So there's certain, planning for liquidity that may be needed, whether it's, how to fund a buy-sell agreements, redemption agreement, or whether there's going to be an estate tax obligation based on the value of your business. So planning for that liquidity as early as possible takes most of these issues off the table, but it's one of the primary challenges that business owners are currently facing. Leadership transition and readiness. Another challenge that most business owners face: who will be taking over the company? Is it, do you have a child who has an interest? Are they capable? Do you have a pool of long-time employees that have an interest in taking over the business? Perhaps it's an outside buyer if no one's available to take over the business. So having that transition, and then on the flip side of that, have that clear communication with those identified candidates to make sure that they're on the same page as you. Asset protection, as any business owner knows, there's significant legal, financial, just operational risk in running a business. Ensuring that there is that barrier between, the business assets and your personal assets is an extremely important part of the planning process, which we'll discuss a little bit later with some of the discussions regarding trust that Richard and I will get into. But, at some point, whether it's business asset or personal assets, you're going to want to make sure that these assets are shielded from legal judgment and creditors. And there's just some easy planning measures out there to make sure that this is done. Maintaining cash flow for desired lifestyle. Again, for business owners, over the life of their life's work here, most of their source of their cash and their income has come from their business. So as they start to think about an exit plan, how are they going to supplement that loss of cash flow? And again, a lot of times business owners, they'll put money right back into their business. So they might not have that nest egg needed for, whether it's qualified retirement assets or just outside funds that they can use to supplement their retirement. So there's some considerations here, and a lot of thought needs to be, discussed on, how to make sure that the business owner and their family can continue to maintain their lifestyle.
So it's use Ralph Wilson as an example. On paper, he was worth, $1 billion, whatever, but it was all the bills. He didn't really have the cash flow. So I think that's always a good example.
Yeah, liquidity. It's
very small.
The number one issue, I think, for most closely held businesses. Estate tax exposure. I think the next part of our life cycle of a business webinar series, we're going to talk about valuations. But a lot of clients might also not know what their business is worth, and furthermore, could be shocked to realize how valuable it actually is. So if you have not received a business valuation, that might be a great starting point to see what you're dealing with. Obviously, the sooner you know and understand your value, if there is a potential estate tax problem, the sooner you can plan for that and make some lifetime transfers, which we'll talk about. It just limits any appreciation of that asset, and it'll grow outside of your estate and pass to your kids tax-free. So that's a consideration. We'll get into some of the federal and New York estate tax changes in the upcoming slides here. And then, perhaps maybe the most important, balancing family dynamics and business objectives. I think every, person doesn't want their family to be in a state of conflict after they pass away or if they become incapacitated. So having a clear, transparent plan with roles, again, clearly defined is very important as you're making your way through your succession plan. And again, succession planning, it's a forward-looking process that will determine how leadership, operations, and responsibilities are transferred if the owner retires, becomes incapacitated, or passes away. Again, it's not a reactive process, it's a deliberate design process to protect the business before the transition occurs. It addresses both planned and unplanned events. I know a lot of business owners say, I'm not going to retire for 5 to 10 more years, I have time. But there's sudden death, a sudden event where you might be disabled. Lacking that plan in place could really put your business in a bit of a state of flux. With the primary goal is to strengthen business continuity by giving employees, lenders, customers, and vendors greater long-term confidence in the company's future. So essentially, I would akin succession planning as a business continuity tool. Your plan will safeguard all your business's value and ensure the company can thrive with the next generation. Just looking just the clicker here. There we go. All right, so you're a business owner, and I don't know if you're 5, 10 years away, but you might be starting to think about your exit plan and just some of the questions you might want to consider. Who will take over the leadership of the business? Will it be a child? Does that child share the same interests that I do? Is he willing to take over the business? Is it a sale to an outside buyer? Is there a couple employees that you want to take over the business? So some of these are just some of the questions you'll start to think about as you make your way through the process. Another one, what role will I, the business owner, have or want after the transition? Clearly defining that role is also an important and often overlooked part of the planning process, whether, there's two sides of the equation. I've seen a lot of times where the kids take over the business and the parents stay on longer than expected, and the kids push them out and it causes a little bit of conflict. Or similarly, on the other side, the prior owner is always getting pulled back in to help right shift the business. So having that clear, I guess, just role of what the business owner will have either before or after the transition is extremely important. How will ownership of the business transition? Couple options there. Gift. A lot of closely held business owners like to gift the interest of the child. Is it a sale? Is it a redemption? A lot of this also plays into the next point of liquidity. Maybe I can't gift 100% of the business to my child because, again, that's the business has been historically my source of funds to maintain my lifestyle, and it might need to be somewhere in the middle, whether it's a hybrid of a gift sale approach. So all of these are good questions to start thinking about as you're heading into this process. Do I have the right people in the right roles? How will family dynamics be addressed? This is the classic fairness first equality kind of debate. Make sure everybody's on the same page. It's well communicated, so there's no sources of conflict. And for anybody who's ever saw the TV show Succession, I think that's a textbook case of what not to do, because it just leads to a lot of family turmoil, which it's one of the primary goals to ensure that doesn't happen. And then perhaps most importantly, what's my timeline? And there's really no bright line test for this. But if you're attending this webinar and you're starting to think about it, your timeline probably starts now to putting those action plans in place going forward. Sooner the better. A couple of factors for that, which we'll talk about, but certainly when it comes to limiting any exposure to estate tax, the sooner you start, the sooner you can transfer assets out of your estate and remove any appreciation out of your estate. All right, I'm going to turn it over to Richard. He's going to get into estate planning and a brief discussion on some of the trust out there and some of the tools we have available.
Yeah, thanks, Adam. My name is Richard Burkowski. I'm an attorney by trade. I joined Tronconi about a year ago. My background primarily since law school has been trust and estates and the taxation of them. So it's just been a great fit being able to join the team and have that background of tax, but also the legal background and what we're all trying to accomplish with business owners, succession planning, and estate planning. And I apologize for the coughing. You're starting a cold or getting over one. I don't know. So now that Adam touched on succession planning, it's going to go right into estate planning, right? So estate planning is really going to be you as the individual, right? The succession plan is all about the company, which will impact you. But estate planning is all about you, the individual, right? You, your spouse, your children. It doesn't have much to do with your business. Your business can impact that from a variety of reasons, which Adam touched on and we'll touch on later as well. So really, it's planning for the next generation of the transfer of wealth. How do we get it from you to your children efficiently, cost effectively, and with minimal tax consequences. So why do we do it? Obviously for your loved ones, right? Whether it's your spouse, your children, your grandchildren. We got to get those assets transferred to the next generation. Estate planning has a lot to do with making it easy on your family for when those life events do happen. Charitable intent, that's another reason why we do it.
Asset protection.
Yep, asset protection. Charitable intent, we can get into that later. We're going to touch on a couple of different trusts that really focus on charity, and that kind of feeds into the next one on the slide. Tax control, right? We want to limit taxes. Charity is a great way to do that as well. And then tying it all back into what kind of Adam was talking about is business succession, right? The estate plan and the succession plan are gonna work together in order to get you on the right track. So this next slide is kind of tying everything together that we kind of talked about already, right? The 4 pillars of an integrated estate plan. I kind of look at it as integrated, right? We're trying to take the succession plan as a business owner and the estate plan as an individual. So we kind of come up with these 4 main keys, right? So control. Who's going to make decisions if you can't? That can relate directly to your business and that can relate to you personally, right? Mm-hmm. If something happens, who's going to run your business? Who's going to step up? If something happens to you personally, what happens to your spouse, your children, your family? Continuity, right? Keeping everything together. Same thing with the business. How is it going to keep operating? And then taxes, right? How do we minimize estate taxes for you personally? Income taxes to your children, taxes to the business, right? How do we try to manage that in the easiest way possible? And then my favorite and the last one is legacy, right? How do we transfer that wealth from your business to you individually and to your children? And legacy can mean a number of things, but primarily, I think it's important as a business owner, legacy of your business, not just personally but professionally.
Yeah, I probably think there should be a 5th pillar for just communication. Make sure everybody's aligned, understands their roles, and everybody's on the same page so that the plan can be run effectively.
Yep. So crucial estate planning documents, right? We've all seen enough TV shows to know that what these documents are, right? Wills, powers of attorney, healthcare proxy, and trusts. I will go through wills on a different slide. Powers of attorney are pretty general, right? It's something that you appoint an individual who will make decisions for you financially, legally, personally, when you become incapacitated and it does, end at death. Healthcare proxy, very similar. It's just going to be surrounded by medical decisions. And we'll get into wills on that.
Yep. This is often called the what if binder. So usually a combination of, if not some of these, mostly all four are part of a person's estate plan. So there's just, it's commonly referred to as a what if binder. What if something were to happen? I have the plan in place for things to continue and people to act.
Okay, so what is a will? It's a legal document that's going to govern the distribution of assets into your name. It's going to determine who gets what when you pass away. I like to give my little speech that everyone listening, whether you have done a will through an attorney, you already have one, right? Every state already has laws in effect that will determine what happens to you when you pass away. So you already have a will, and you basically, if you don't get a personalized will, you're telling the state that whatever you say, that's how my assets will be distributed.
Which you don't want to do.
You don't want to do that. You don't want to leave that up to the state to determine who gets your assets, who gets what, and your loved ones would have absolutely no control. So it's very important to kind of understand that whether you've done a will, you kind of already have one. So it's very important to start to think about these things because you want your family members to be in a better position when you're gone.
Yep. And I would say laws change constantly. So if your will is, I would say 20, 30 years old, maybe even 10, certainly get it refreshed, get some clean eyes to take a look over it and see if anything needs to be updated or adapted for any new law changes or new developments since then. Yep.
And that's going to kind of lead into the next one is what happens when you die without a will, right? So we call that intestate.
That's good.
Right, that's okay. So if you die, like we already said, if you die without a will, the state is going to determine who gets what assets, and that's what they call as intestate. So you've probably heard that before. You don't want to be in that position because it's just not great for your family. Yeah.
Yeah, then I always find it funny if you see a will that was done in the 1970s compared to a will that's done now.
Yeah.
It is about a good 50 pages longer now. So it just gives you a sense of just a little bit more of the complexities that there are in today's age.
Okay, so administering a will. So you have a will, right? Let's say you went to an attorney, you signed it, you pass away. When you have a will, what's going to happen is you have to enter what's called probate, right? It's a process. There's a judge. It's called surrogates court. Your family's going to have to hire an estate attorney, and they're going to have to file the will. The judge is going to go through a process, and they will grant, the executor
stamping approval on the will.
Yeah, we've all seen it, right? Everybody's seen, the TV commercials, a show, right? Somebody has a will, they probate it. You heard the term executor. The unfortunate part of this is that, it's a time-consuming process, right? You have to go to court. Everybody knows the court takes time. There's filing fees. You have to find an attorney to do it. And that's really going to take money out of your estate, right? Even if it's a simple estate, those are hours, that's time, those are fees. And it could be a situation that you can avoid, even going to probate.
Should probably avoid.
Yep.
So I know we're going to bounce around a bit. And it's tough to make this topic fluent and flow concisely, but yeah, real quickly. So the one big beautiful bill that was passed in July, I'm sure everyone's heard. It removed the sunset of the increased federal exemption and in fact made it permanent, increasing it to 15 million for individuals, thereby 30 million for married couples starting in 2026. And these figures will be indexed annually for inflation. So that's great. The rush to do all this advanced planning by the end of 2025 before the exemption scale back is off the table. I would say a pause. I think we're still encouraging most people to be diligent and and continue with the planning and act as quickly as possible. You know, even from the standpoint of a loan, that assets tend to grow very quickly. So the sooner you can transfer these and get these out of your estate, the appreciation is out of your estate.
Laws change, right? Just
Yep,
because one,
laws
just 'cause one
change.
thing was signed, you know, a couple of years
Yeah,
ago.
laws change, you know, it seems the next president could easily unwind all this, so keep your foot on the gas. And, you know, I know a lot of people might say, you know, I'm definitely under the federal exclusion between me and my spouse, but you just look at what happened in the economy the past several years. Asset growth is at a historic levels. They're growing very quickly in decades, if not even years. It's very likely that your assets will outpace the inflationary index adjustments. So continue with the planning and just stay diligent about that. For New York State estate tax, for all our New York residents attending today, that exemption for 2025 is, let's say, approximately 7.1 million. You know, and I'll talk a little bit about all this and bounce around a little bit, but the New York estate tax works a little bit differently than federal. Whereas federal, you're taxed on the amount of your gross estate over the exemption. New York is what's referred to as a cliff tax. So once you reach that exemption, with the high end of the cliff of 7.5 million, the entire estate becomes taxable from $1. So it's really a complete shift from what federal allows. And furthermore, federal has portability. So for married taxpayers, the unused exemption from the first to die spouse does port over to the surviving spouse, and they can use. For New York, there's no portability, so that's lost. So, you know, the key is here is don't think about this exemption as really I guess a deduction from your gross estate. And if you are a married taxpayers and you're sitting on $10 million of assets, just don't think that, oh, I got 7 million for me and 7 million for my wife. The best avenue is probably not going to be to leave all the assets to each other, because what's going to happen is that when the first person dies, the surviving spouse absorbs that $10 million estate, and now they have an estate tax problem for New York, and the entire estate becomes taxable. And we'll get into a little bit later some really easy planning strategies out there, such as the credit shelter trust, that can just remove this issue off the table. And it's just a couple simple clauses you add to a will, and it just provides your executor the flexibility to plan for any New York State estate tax.
I think that's me. So what is a trust, right? So, you know, we tend to use, you know, big words and you know, words that sometimes normal people can't understand, but it's basically a legal agreement between a trustor, a grantor, settlor, and a trustee. What does that even mean, right? So, so the main idea of a trust is that one person is going to take their assets and they're going to place them into this vehicle, that's the trust, for the benefit of someone else. Right? It's a pretty simple concept, right? They're taking what they have, they're going to put it into this trust, which is the vehicle, for the benefit of someone else. It could be a spouse, it could be a child, it could be a grandchild. And the trustee is going to ensure that these wishes are carried out, and their powers and everything else will be inside that trust document. But that's really the crux of it. And I think it's important to kind of simplify it down, because we use a lot of big words. So the benefits of a trust, these are going to be super general, because we're going to start getting into different kinds of trusts in a second. So trust will avoid probate, right? So the thing we talked about, where, you know, you're going to have to go to court and, you know, pay an attorney to submit the will. You know, a trust will avoid that entire process. Control over assets, right? So immediately your family will have control over your assets. Tax planning, we're going to talk about that, right? If you start to get into some certain higher thresholds with the estate tax, trusts are a great way to avoid a lot of those taxes. And then incapacity planning, right? If something happens to you and you become incapacitated, you know, a trust is an easy way for, you know, the just continuity, right? For whether it's a business or personally, a trust is a great way for that to have a good solution. Okay, so 4 different types of trusts. There's the revocable living trust, and we're gonna touch on pretty much all of these, I believe. Adam's gonna get into the revocable living trust, I believe. But it's the most common form of a trust. Assets are placed into the trust, but you control everything while you're alive. They're super common. A lot of you might already have them. You can modify the agreement at any time you want. There's absolutely no tax implications while you're alive, income tax or estate tax. The main reason for these is to avoid probate, right? So when you pass away, everything's going to go into that trust. Your trustee will distribute everything. You don't have to pay an estate lawyer as long as everything's in that trust, and none of your assets go to probate. So it's a great way to save money because you don't have to pay an estate attorney. Your kids will have your assets sooner. I know Erie County has a pretty big backlog still of probate cases, and it can take time. So it's just a really nice way to get those assets cleanly to your kids very fast. Testamentary trusts, super similar to a living trust. However, no assets are ever transferred until your death. The trust is actually created through your will. So you're still going to have a will. The trust will just be created out of that will, and there'll be language inside the will that will spell that out. A downside to this is that you will still have to go to probate because you have a will. So the trust will be created out of that, but you still are going to have to go to probate. You're going to have to hire an attorney. The benefits of this, though, is that there's a little more court oversight if you're distributing assets to, minors. You can also set age limits on distributions. So it could be a good solution for people.
Yeah, I don't want to scare
younger
people out of
children.
probate, but it certainly could have a fit in everybody's estate plan depending on what their intentions are.
Yep.
Like a testamentary trust.
Yep. So tax planning trusts, that's kind of what we call them. It's going to be, many different type of specific trusts, but the main idea is that these trusts are going to be used to minimize estate tax. So, if you're in that New York threshold or federal threshold, these are going to be ways to kind of, minimize your estate tax. And we're going to get into some of those later. Special needs trust, I should probably just real quick. Special needs trust, it's just used to protect beneficiaries with disabilities who cannot manage any assets themselves. It's usually designed specifically to allow those beneficiaries to still receive funds from the public, such as Medicaid, without jeopardizing.
Okay, we'll get into revocable trust briefly here. I know Richard touched on some of it. But really, it's a standard part of everybody's estate plan now. They're becoming more and more common. They're usually done, they're handcuffed with a will. Both documents are part of an estate plan. So it's really a vehicle whereby a grantor titles assets to a trust and appoints a trustee to oversee the management and administration of the assets while the grantor is living. In most cases, the grantor will assign themselves as a trustee. You could assign somebody, not yourself, whether it's a kid, a trusted advisor, a friend. Again, you maintain full control over this trust. You can revoke it at any time. Nothing's going to change from a tax perspective. You still own the assets, so it's not even going to help you from an estate tax standpoint. But it's extremely helpful for situations where not only to avoid probate, but if you were to become incapacitated, this will allow either your successor trustee to step in if you originally put yourself on as trustee, or the non-grantor trustee can immediately jump in and handle your affairs. It just provides that flexibility, and just everything continues without disruption. Similar to the benefit of not going through probate is that it also maintains privacy too. So I know that's a key component for a lot of people. They don't want their financial affairs out there. Revocable trust will avoid probate entirely, and then, likewise, you're going to maintain your confidentiality. I think I touched on it, but this is not effective for any kind of estate tax mitigation strategies. So you still control the assets, and when you die, they're considered yours and they're part of your taxable estate. And then one last thing. So most times, as I mentioned, that these usually go in accordance with a lot of wills. The drafting of these agreements, there's usually a pour-over clause in the will that will stipulate, once I die, if there's any assets that are not title to the trust. Upon my death, they're going to pour over into this will and then be administered in the terms of the revocable living trust. So it's a nice catch-all to, maybe, just protect some assets you may have forgotten about, and they'll be dumped into the trust and then managed in accordance with this trust.
The idea of that is that if say you have one bank account you forgot about, you don't have to go to probate. It just pours right over. So it really, it's a nice tool.
I lost my clicking abilities.
Sorry, it might have been me.
Okay, so now we're going to kind of get into some different types of trusts, and we'll start touching on some estate planning techniques. So this is a credit trust or a bypass trust, also called an AB trust. It's what I would say the simplest of all the tax planning trusts would be. So basically, it's created upon death and funded with estate assets. So these assets for the first to die spouse would flow to the surviving spouse. The trust is going to be managed by a designated trustee, and the surviving spouse will never actually take control of those assets, and we'll explain in a second why that's super important. And therefore, the transfer doesn't actually add to the surviving spouse's taxable estate. So this is really related to what you were talking about with New York. It's a great way to, it's simple, it's easy. If you are around that, New York estate tax exemption, this is one way to really start to not have any problem with New York.
Again, if you had that example where a husband and wife each own $10, you don't want all the assets to be left to the surviving spouse, putting them in an estate tax problem. So what this approach would be, upon the death of one of the taxpayers, I set up a trust. I funded with $5 million, which will pay an income stream to my wife for her life. But those $5 million of assets are not considered part of her estate. And I always just assume the guy's going to die first. Sorry, I use these terms, but it's generally how it goes. So those, and the other $5 million pass to to the spouse. They'll have control over them, but by doing this, you removed $5 million from the collective estate from the surviving spouse, and they also get to enjoy the income of the entirety of the assets. So it's a great plan to, if you're in that, 10, I guess maybe $8 to $15 million range. It's a very good planning opportunity.
And we'll get into some other charitable ways to get around New York too later on, but it's a simple way to kind of set it up.
We're going to discuss some common estate freeze planning techniques. I'm not going to go through all these. We're going to get through them in detail later, but an estate freeze is essentially locking in your estate value at a point in time, meaning that you remove any future appreciation of those assets from your estate. One of the trusts available is a qualified personal residence trust, and this is a common estate freeze technique, which allows you to transfer your personal residence, primary or vacation home, to a trust for the benefit of usually your children, but any beneficiaries of your choice. The key here is that the grantor, the person who owned the home, retains the right to enjoy and live in the residence for a fixed term of years. After that term expires, the assets then do pass on to the children. At that time, if the grantor wishes to stay in the home, they're going to pay their presumably children fair market value rents on an annual basis. And I know a lot of people might be thinking that's weird to do. How does this save taxes? The benefit here is that for a lot of people, it could be for Medicaid planning too. Their home could be one of their largest valued assets in their estate. So when you make this transfer into the trust, the value that you used as part of your exemption is going to be the fair market value of the home at time of transfer, less the present value discounting for the retained use. So if you have $1 million home, I'm going to make up numbers here in rates because it's all dependent on the IRC 75/20 rate. Instead of transferring that asset and it cost me $1 million of my exemption, I can add in the present value of my retained use, or I guess what the kids would get at the end of the term, and it might knock that gifting value down closer to say $600,000. So it's just, again, you just couple of these strategies up, and you can get some some real benefits of saving on some of the value of your assets.
Yeah.
You want to talk about that?
Yeah, it's kind of related, just because it has to do with property. A life estate deed is also an alternative. It's become pretty popular over the last 5-10 years.
More popular, I think, now.
Yeah, I'll just touch on it briefly. Basically, you establish what's called a life estate deed. You specify, you're gonna work with your attorney, and you specify yourself as the life tenant and your child as what's called the remainder man. And during your lifetime, you continue to live in the home, and you pay all taxes and insurance. The benefits of a life estate deed, as well as QPRT, you're going to avoid probate. You can retain control and use. You'll get some protection from creditors. And the main thing with the life estate deed is your beneficiaries at the end will receive that step up in basis after death. So that could be some nice tax savings that you're passing on to your children. The few cons though with the life estate deed is that remainder man, or your child probably in most cases will have an interest in that property. So if you go to sell it, that can create some administrative and tax problems if it's before your death. And it also can complicate Medicaid eligibility. So that's another one that people should be weary of about. I would definitely say if you're leaning towards one of these, it's important to talk to an estate planning attorney and a CPA when implementing some of these, because it could have some consequences.
Yeah.
But definitely good strategies.
That's good.
Sure. Okay, so a spousal lifetime access trust, I won't spend too much time on this just because it's pretty highly complex. So it's a complex estate planning technique. It's very beneficial for families who could be near that federal exemption. So basically, the grantor is going to create a trust for the beneficiary of their spouse and child. You're going to fund that with stock. We see that a lot. Units or cash. The estate's going to lock in at that fair market value at the time of transfer, and all that appreciation is going to occur outside of the estate. So basically, you're funding that trust, trying to use up that federal exemption, that $15 million, which it will be next year. Yeah. And oftentimes when we use slats for those higher net worth clients, you're going to see two of them at the same time, because the husband's going to do one for the wife and the wife's going to do one for the husband. So they're going to use up that entire exemption at one time. So it's just a common, it's a good tool. I would say it's a little more of a complex tool. And it's just important I will say there's very strict rules in regards to slats from the IRC, IRS as well, court cases. So you definitely want to make sure you're crossing your T's with any of these, talking to an attorney as well as a CPA, because you can get into a little bit of trouble.
Yeah, and I know we mentioned, when talking about some of these trusts, we'll mention the federal gifting and the exclusion, and you might be saying, hey, I'm not in a federal taxable state, I never will be. But if you're a New York resident, really the figures you're playing with are $7 million per taxpayer. So it may, a lot of this planning will still be relevant and still be needed. We just use the term federal when talking about gifts, because New York does not have gifting. They conform to federal rules. So I just wanted to make that clear. So, you don't have to be sitting on 40 million or 50 million of assets to have, to utilize some of these opportunities. No. If you're a New York resident, that's going to drop down significantly, and you probably should consider them.
And if you also have assets that you think might appreciate over time, so if you're on the ground floor of something, business owners, it's definitely a tool. It doesn't have to be for someone that's already worth, $15 to $20 million.
Yeah. Oh, okay. Yeah, I'll talk about intentionally defective grantor trust real quick. It's another, a lot of complicating terms, but at a high level, what this is, it's I'm going to try to give an example to talk about this, but so essentially a grantor sells an asset to a trust in exchange for a promissory note. So the value of that note will be the fair market value of the property contributed at the time of transfer. So a common asset here will be closely held business interest, other maybe real estate that's expecting to explode in value. And the key, I guess, factor here is that this trust is under grantor trust status. So that transaction between you, the grantor, and your trust is ignored for income tax purposes, since taxpayers can't engage in a transaction with themselves. So by making this trust intentionally defective, that allows you to lock in that estate value. So, to put it in perspective, if I am a 25% owner of a business and that business is worth, I guess the fair market value of those interests are worth $1 million, I'm going to contribute it into a trust in exchange for this promissory note. So this trust will pay me $1 million over a set term of years. Upon the term expiring, those assets are going to really be for the benefit of my beneficiaries, and all the appreciation since I made that transfer is now out of my estate. So that's the benefit there. So it's ideally you want to use assets that produce liquidity so they can make those promissory note payments back to the grantor, but you can also make those in kind. So if I, in my case, in my example where I did contribute the LLC interest, if there wasn't being cash produced from this LLC, I can also issue partial interest back to me in satisfaction of that promissory note. But it's a real effective tool for locking in and freezing that estate value at the time of transfer. Like I said, a great option for closely held business interests that someone could see having a large appreciation or significant appreciation event at some point in the future. So this is a very unique tool for doing that. But again, it's just another estate freezing technique, as was the SLAT, the Spousal Lifetime Access Trust. What time are we intending to go till?
We're at 12:48 right now.
Grantor retained annuity trust, GRATs. I'll talk about this quick. It's a similar concept to the intentionally defective trust. I'm going to transfer an asset into a trust. In exchange, I, the grantor, will receive a fixed annuity back over a set term. Again, rapidly appreciating assets are used most commonly for this structure, and it often provides a low use of your federal exemption. That being the amount of my exclusion I will need to use will be the fair market value at the time of my transfer, the asset value at the time of transfer, less the present value of the retained annuity. Very common in low interest rate environments. If structured properly, the gifting value can usually be close to zero, and that's called zero out grants. After the annuity period ends, the trust assets pass to the beneficiaries. Any future appreciation is out of your estate, leaving more money in the hands of your beneficiaries. So the key is considering where we are right now with the interest rates. You're probably not going to see a lot of these, but again, like we had a few years ago, as Richard and I were discussing before we came in here, those interest rates were low, so it provided a lot of opportunities for everybody to structure these zero out grants. And as long as the anticipated rate of return of those assets in the trust exceed the current interest rates, you're going to make out and really shield some taxes or shield some assets from estate taxes.
And I'm going to stop you for 1 second before we move to the charitable giving slide. Bill had a question on the previous slide. Do you need to pay rent in addition to the cost of living in the home?
For the
Keep it or keep it? No,
you need to pay rent in addition.
no, because you still maintain the right to use the property.
Yeah.
You pay all the mortgages, you pay the insurance. You're basically giving an interest to a remainder person, which is probably going to be your son or daughter.
Is that for the life estate deed?
Yeah. I think so.
Yep.
You might have a gift return at some point in that process. The attorney would work with you. But
yeah, it's no rent, right?
No,
Same page, yeah.
You're responsible still to pay the mortgage if you
Yep.
have one,
Yep.
insurance, property taxes.
Yeah, it's really your home. Yeah, I don't think much changes there. So no rent to the beneficiaries.
Okay, Bill, hopefully we answered that for you. If not, let us know. I'm sorry, I'll let you continue on. We've got about 10 minutes. And I think you only have a couple more slides left, so.
Okay, yeah. So again, another part of everybody's estate, not everybody's, but charitable giving is often a part of estate planning. There's a few high-level buckets here. Outright gifts, those you get the income tax deduction. A transfer of assets to a charity is not a taxable transfer for estate purposes. So they're a great way to, if you do have a significant income tax event in a certain year, considering an outright gift. If you're going to make a large gift, consider doing it of appreciated securities. Not only will you, avoid any capital gain on the unrealized gains on that security, you'll get the deduction at the current fair market value. Donor advised funds, private foundations, great avenues, great strategies for any estate plan. I don't want to dive too much into those because it's a topic on its own. And then charitable trust, charitable remainder trust, and charitable lead trust. I'm going to go briefly through those next. Nope. It's a little bit of a delay. There we go. Charitable remainder trust, again, another estate freeze technique of sorts. So it's a trust that provides an income stream to the donor or beneficiaries for a life or a term of years. Upon the conclusion of that term, whether it's that set number of years or upon death, remaining assets pass to the designated charities. So what happens here is you're going to contribute assets into a trust, and really an annuity will be given to you over the term that you select. It can be fixed, it could be a percentage of the trust assets. A good, benefit to this is you're going to get an immediate charitable deduction in the year the gift is made based on the actuarial value of the charitable remainder interest. If the donor is the only income beneficiary, meaning I set up a trust, I transfer assets into it, it's going to pay me a term over 10 years, and then the rest goes to charity upon the conclusion of that term. There's no taxable gift upon transfer. If there is a presence of a non-grantor income beneficiary, not including your spouse, because that'll be, again, a marital deduction, then there could be a slight taxable gift needed because you're giving a benefit to someone that's not yourself or your spouse. Again, a great way to provide predictable cash flow for retirement, all while securing some income tax deductions. So good all around.
Really guaranteeing you or your spouse's income,
Yep.
and then knowing your assets are going to go to charity. I think we see it a lot with
Yeah.
people that might not have children, or their children are already well off. You know that at the end it's all going to go to charity, but you're really building in that income for you.
Yeah, I've been seeing a lot of it recently. So it's shifting from providing specific bequests via will to then fast tracking that and doing it now, getting some income tax deduction.
Yep.
Getting some income in a tax efficient manner.
Yep.
Charitable lead trust.
Okay, Bill's got another question before we move on again. So can it be canceled before term with proceeds of trusts to qualified charity?
Meaning, can the trust be revoked? It's probably a legal question. I don't know. Yeah, you might. There's probably some complexities with doing that. So, yeah.
Still like to go to charity early. Is that what he's saying?
Well, we can
We
always,
can reach out to Bill.
yeah, Bill, we'll reach out to you on this one. I don't think it's a
Oh,
straightforward.
yeah.
Like,
So
did you
can
want
cancel
charity
it
to go
before
to-
the term?
Like if you're like, I'm good, I don't need.
Probably.
income
There's probably
anymore.
terms in there. As long as
As long as
you're not
charity.
obtaining the assets back, the trust usually provides some flexibility in that regard, but we can get back to you, Bill. Charitable lead trust, it's actually the opposite. So the charity is going to receive annual payments for a fixed term during the donor's life or a term of years. After the term ends, those assets revert back to the donors, or they then pass on to the beneficiaries. So this is, again, another, I guess, depending on which way you take it, CLTs they're much more flexible in design. So if you have a grantor charitable lead trust, the trust assets return to me. So in this situation, I give assets to trust, and I name a couple of charities that receive income payment or annual payments for 10 years. At the end of that 10-year term, those assets come back to me. The benefit there is that I get an immediate income tax deduction in year one based on the value that I transferred to the trust. On the flip side, the non-grantor charitable lead trust. The trust assets upon the conclusion of that term pass to my beneficiaries. So this is another situation where you have an estate freezing technique because my gift would be limited to the fair market value of those assets at the time of transfer to the trust, less the present value of the charitable lead interest. Again, another potential for a zero out planning opportunity depending on the interest rates. But again, since there's a charitable lead aspect to it, charitable transfers are not considered part of a taxable transfer for federal purposes. So that's why you can play that game and negate down the actual value of that gift when making those transfers. So again, another estate freeze technique. And then real quickly, this will kind of go full circle to some of the succession planning aspects we talked about previously with, illiquidity and providing cash flow in retirement. Life insurance is usually a standard part of everybody's estate plan. As I just discussed, it addresses issues of liquidity for estates, primarily with illiquid assets, which I think most business owners find themselves in. It can provide immediate cash funding for estate taxes and inheritance equalization. And what I mean by that is, say you have a kid that wants to run the business and you have a child who doesn't want to run the business. And if most of your net worth is tied up in the business and you turn it over to him to then continue and be your successor, you've really, left, one of your children's a little high and dry. So you see a lot of times where this life insurance mechanism will be that avenue to equalize everything. Irrevocable life insurance trust, another great estate tax saving strategy. So here you're going to fund a trust with with cash. The trust is going to purchase a life insurance agreement. So that life insurance is out of your estate because typically the beneficiaries of that trust are your children. So the extent of your taxable gifts on an annual basis is limited to the premium payments, which can usually be leveraged with the annual gift exclusions or crummy powers, and really, almost get you to this point where you're not getting any exemption.
With those annual exclusions just continuously increasing, I think that's going to be, it's already popular, but it could continue to become more popular because now you got, 19,000 for you and your spouse to play with for premiums. I mean, it's
the value of some of these policies over years,
right.
It's a ton of value that's now out of your estate.
It's already built in. You're never going to forget about it because you got to pay the premiums. So I think it's a good. It could see.
It's always in the crosshairs, I think, of new legislation about disbanding that as an abuse of trust, but so just hasn't happened yet. So get it next to your grandfather. And then I think that's it, which we have one more slide here on strategic gifting and leveraging valuation discounts. But I think, we can probably bypass this slide for the time being because that's going to be a primary focus of our next webinar. Remind me, Carolyn, December 2nd, when we talk about valuation. Nice teaser, yeah. So I think that's it. If there's any other questions, thanks for having me and appreciate everybody attending.
Yeah, appreciate it.
Before we let everybody go, I'm going to give you a minute to put questions in there while anybody's entering questions. Just want to get a little bit of information. How are you feeling based on what you learned today? Kind of see where you're at and where we can be helpful to you. As I mentioned, we will be sending you an exit survey when we finish up today. So if you could please complete that, and then I will also be sending you the slides and link to the recorded session after the webinar sometime this afternoon. I will get that out to you. I'm going to close out the poll just quickly to keep us moving forward, but it looks like generally a lot of people are in good shape. And people have some information to get started, so we seem to be in a good spot. If you have any questions, throw those in there. Yes, I will send you a copy of the slides this afternoon with the link to the recorded sessions. Somebody just asked. Our upcoming webinars, you should be getting the invites for December 2nd, will be the third in this series of what drives value. So this will be valuations on the business. And then December 16th is getting your company ready for transition, whatever that transition is going to look like. So we'll be going through that. Lastly, the contact information of our experts. We thank everybody for joining us today. Please reach out to us. Let us know how we can be helpful. If you want to go to our past webinars, you can use the QR code for that. Join us on LinkedIn and join us again on December 2nd. Thanks, everybody. Have a good day.